Hello class, and welcome to this lecture on capacity and general assent. Now, the main thing we're going to focus on inside of this lecture is the capacity element of contracts, okay? And there's a lot of different ways that capacity is discussed, but I like to start this lecture with reading you a case, okay, on capacity. But before I do that, I want to define capacity in a contract sense, okay? Capacity is the ability to understand that a contract is being made and to understand its general meaning, okay? So I want you to make sure you know that definition. I'm going to repeat it, okay? Contractual capacity is the ability to understand that a contract is being made and to understand its general meaning. So what they're saying is you do not have capacity to enter into a contract if you don't have the ability to understand. So say for instance, this happens a lot with dementia. So someone is in the later stages of life and they don't quite understand what's going on. They enter into a contract and later they want to void the contract because they did not understand what was going on, okay? So you have to be able to understand the contract. So that would be one. Another one would be children. And we're going to kind of get into that, on contracting with people under the age of 18. But here's the case I want to read to you. Okay. An Alabama statute provided that a married woman could not sell her land without the consent of her husband. So there's a statute in Alabama that says, hey, females can't sell any property, like land property, like real property, real estate, without the consent of their husband. Okay, this is Alabama, and there's this lady, her name's Mrs. Montgomery. Okay, Mrs. Montgomery would like to sell her piece of land. She contracts to sell her piece of land to Mr. Perry, Mr. and Mrs. Perry, okay? Their status and gender doesn't matter, but it's Mr. and Mrs. Perry. So Mrs. Montgomery wants to sell her piece of land that I believe she inherited from her family, here nor there, but I'm pretty sure that's how she obtained it, was through inheritance, to the Perrys, okay? Well, Mrs. Montgomery's husband says, no, you can't sell that piece of land to the Perrys. So Mrs. Montgomery calls the Perrys and says, hey, listen, I've decided not to sell it. And the Perrys say, well, why? I mean, why won't you sell it? We have a contract. She goes, well, my husband doesn't agree and I'm not going to sell it. So the Perrys sue her and try to get what's called specific performance, which means that the court is going to make her sell it, okay? And her defense is that Alabama has a statute that says she cannot sell the land unless her husband agrees. So, interesting, because what it is that the statute says basically that a woman, a wife, it doesn't say a woman, a wife, doesn't have, let's go back to the definition of contractual capacity, the ability to understand that a contract is being made and to understand its general meaning. So that's what capacity means. Alabama says you don't have capacity if you're married. So they go to trial, and no big shock here, the statute is ruled unconstitutional. Based upon the federal and state governments both have the 14th Amendment, which gives equal protection under the law to all people, regardless of your race, gender, creed, whatever that entails, and that the fact that such an unequal treatment had once been recorded as proper does not justify its modern continuation, is what the justice said. This case was in the 1990s. That's not that long ago. I know some of you probably were born, in the late 90s, early 2000s. Some of us, like me, were in high school in the 90s. But this is not old law. There is stuff like this still going on today. But that was in Alabama in the 90s. A woman doesn't have capacity. And what is capacity? The ability to understand a contract. So, I like to give that case just as an example of when we're talking about capacity, a lot of our capacity laws are antiquated. I mean, they really are. And the justice really talks about this inside of the text when he says, the fact that such unequal treatment had once been regarded as proper does not justify its modern continuation. And it's a great sense in the fact that we evolve inside of the law, and the laws are constantly changing, and they change with societal changes. And that's an example of one of them. So, obviously I don't like to, teach too much out of books and texts and cases and such, but every once in a while I like to throw something in there. So let's talk about minors. I mean, minors is a huge area of capacity, okay? So here's the deal. If you're under 18, for the most part, you're considered to be incapacitated. You don't have the ability to understand the contract, okay? Now, there are some exceptions, a couple exceptions. One is most states have emancipation laws upon a child either becoming pregnant, so now you're a parent, or a child becoming married. Okay, so a lot of states allow for someone under the age of 18 to get married with parental approval or court approval. And at that point, those people are emancipated and considered adults. There's also emancipation statutes in most states. There's one in Florida. At the age of 16, someone can petition the court to be emancipated if they can show that they are self-sufficient. So there are different ways that, a minor can still have capacity in those situations when there's either a law or a court has granted them that right. But in general, if you're under 18, you can't contract for most things. Now, this is something that you'll want to know. Minors can contract for some things, so let's talk about it. And it's basically necessities. So that's what you need to know. They can contract for necessities. And so what's a necessity, or what's the contractual capacity? Okay. Kid goes into convenience store, picks up candy bar, walks to the register, hands them the candy bar. The clerk says that'll be $1.50. They hand the clerk $1.50. They walk out with candy bar. Well, we have a contract. Just happened. So and let's talk about the contract. Kind of a review is we had an offer, okay? And the offer was he brought the candy bar. He says, "How much is this?" She says, $1.50. There's the offer. He accepts by handing her the money. And the consideration is the money and the candy bar. We have it. But what we don't have, or the question that we must answer, is capacity. Can a minor buy a candy bar? So say the minor gets to the car, and he gets in my car, and he says, "Here's my..." I said, "Where'd you get the candy bar?" "Oh, I just bought it from the clerk in the store." Can I, as a parent, walk in the store and require them to refund the candy bar? And the answer is no. Okay, the answer is no. When it comes to necessities, and these are necessities that I want you guys to know. Necessities regarding health, education, shelter, comfort of the minor. Okay? Let's talk about it. So, it's basically anything for health and wellness, but our food is health. Okay? So, a candy bar is considered health. So, and the reason we do that is that, children need to be able to make certain purchases. Happens every day, all across America, millions of times every day, a student purchases food at a school. Every day. Think about it. You go to school and you grab a carton of milk and it's 50 cents. That minor just contracted with the school to buy the milk. Happens all the time, okay? So necessities a minor can contract for. But there's a lot of things a minor can't contract for, things that aren't a necessity. So let's talk about some things that wouldn't be a necessity. I mean, we could go with a diamond ring. Okay? Now, minor says, I'd like to buy a diamond ring. Okay? And store clerk says it's $1,000. Minor hands the $1,000 to the clerk. Clerk hands minor diamond ring. We have offer, we have acceptance, we have consideration, we have a contract. Minor now gets in my car, and I say, where'd you get the diamond ring? And he's like, oh, I bought it. Now, the store must return the diamond ring because they don't have a contract. Because the minor doesn't have capacity to buy something that is not related to health, education, shelter, okay? Or comfort of living as well. So that's the big thing, is diamond ring doesn't fall into that. That's not food. It's necessities, okay? They have the right to contract for necessities. Diamond ring's not a necessity. So it brings us to an interesting question, though. And it's definitely something that is highly tested, okay? Is contracts with a minor for even, say, the diamond ring, those are voidable contracts. They're not void, okay? And what do I mean by they're voidable? So what that basically entails is that the minor can void the contract, but the store owner cannot, okay? So say store owner says, oh man, I shouldn't have sold that ring for $1,000. I could have got $5,000 for it. He can't call up the minor and say, oh, my bad, I want the ring back, you're a minor. No. People with capacity understand the contractual obligations, and they cannot void a contract. Only the minor can, okay? So the contract's not void. So, and that's a tricky test question sometimes you'll see on our exams, is it's not void, it's voidable, okay? So if exams will ask, is this A, contract good or valid? Is it void or is it voidable? The answer is voidable, okay? So it's voidable if the minor decides to do that. Now there is liability of a co-signer, okay? When a minor makes a contract, another person, such as a parent or a friend, may sign along with the minor to make the contract more acceptable to a third party. With respect to other contracting party, the co-signer is bound independently of the minor. Consequently, if the minor disaffirms the contract, voids the contract, the co-signer remains bound to it. This happens all the time. Parent takes their kid into car dealer and they contract for the sale of car. And the car's no good, whatever the case may be, parent's trying to get out of it. Well, the kid can get out of it. He's not bound by the contract, but the parent still is. Okay, so we want to make sure we understand liability of a cosigner. Okay, so that's kind of how that works. You got to make sure you understand that it's voidable, but the parties with capacity, they're still on the hook. The only people that ever get out of this are the people with no capacity. That's what you really have to understand. Another type of incapacity is mentally incompetent people. Okay, so I mean that happens a lot, across our nation as people get older. It can happen to younger people as well. People can develop mental health issues that render them incapacitated to understand the complexities of a contract. So that's another way. And a third one is intoxicated persons. Okay, so this is interesting. So I am going to, obviously I don't like reading stuff out of my books, but I'm going to read this, okay? The capacity of a party to a contract and the validity of the contract are not affected by the parties being impaired by alcohol at the time of making the contracts, so long as the party knew that a contract was being made. So I can be drunk, okay? I can be as drunk as I want. And as long as I understand we're making a contract, we're good. The problem is sometimes people are so intoxicated, they don't even know what they're signing or talking about. So your friend is had way too much alcohol to drink, and they're just kind of, kind of thing. And you look over to them and say, "Hey, can I buy your car for a beer?" And they're like, "Beer? Yeah, I want a beer." Or, "Yeah, give me a beer." I mean, they don't even understand that we are talking about their car. All they heard was beer. They're intoxicated. That is, you can't do that, okay? But if I've been drinking and I'm intoxicated, but I understand we're talking about a car here, capacity is there, okay? Mistake. Now, mistake is an interesting one, okay? And I don't want to get into the weeds of mistake, and I very rarely test on it, but I will give you kind of an example. Is if the mistake is mutual, okay, just a mutual mistake, you can't get out of the contract. So, example is, I want to purchase from you a stove for my restaurant, okay? It's this big, fancy commercial stove, and you, the seller, thinks that it has the capacity to hold 18 cheesecakes and cook them all simultaneously. I do too. I look at it, I fire it up, I'm like, yeah, it can hold 18 of my cheesecakes and cook them all the way through. Both of us, yeah, it should be able to do that. I get it home, I get it to my restaurant, I plug it in, I put in some cheesecakes, and it only fits 10 cheesecakes. Well, it's a mutual mistake. I can't get out of it because I made a mistake, okay? Now, what if it wasn't a mutual mistake? And this is where all kinds of things are litigated, and we don't want to get into the weeds of it. But what if I'm the restaurant, I'm selling the oven, and I know it can't hold 18 cheesecakes because I cook cheesecake, and I've never gotten more than 10. But I tell you, or you say to me, "Hey, you think this can hold 18? I'm like, "Oh yeah, 18, no problem." Me knowing I'm lying, I'm committing fraud, okay? You're going to detrimentally rely on my statement. There's a whole area of law on that. But basically what I want you guys to get out of it is that if it's truly a mutual mistake, you can't really get out of the contract, okay? So, now, fraud. Now, I definitely want you guys to know this, okay? So we are going to talk about the elements of fraud. Fraud is incredibly highly tested, and just what fraud is and what are the four things that make up fraud, okay? Fraud is making a material misrepresentation. So I'm telling you something that's important, okay? The oven, and I'm saying it can cook 18 cheesecakes, or it has a butane 1500, convection system, and it ain't even a convection oven, okay? I'm making a material misrepresentation. I am just flat out lying, okay? So fraud is making a material misrepresentation of fact with, you need to know these, knowledge of the falsity or reckless indifference to the truth, okay? So one is, what you're saying is false, or it's just reckless. I say to you, "Hey, does this have a convection system?" And you're like, yeah, but you don't look, you don't know, you're just saying yes. That's pretty reckless, okay? So one, it's false. So you can't commit fraud if you didn't intend or recklessly commit fraud, okay? It's an intentional tort. We've talked about that. It requires intent, okay? If it wasn't intentional, it would have been a mistake, okay? All right, second thing, the intent that the listener will rely on, okay? So I have to think that what I'm saying you will rely on in considering whether or not to purchase or come into a contract. So if I said, going to the oven thing, and I say, yes, it cooks 18 cheesecakes, well, I know that you cook cheesecakes. I know that you want to cook 18 cheesecakes. You've already told me that. I know you're relying on this information. So number two, The intent that the listener will rely on the information. Number 3, the result that the listener does actually rely on it. So I say, hey, it can cook 18 cheesecakes. And I say, this guy don't know what the heck he's talking about. He don't know crap about cheesecake. He cooked the little cheesecakes, in this little 8-inch pan. My cheesecakes are in a 14-inch pan. He doesn't know what kind of cheesecakes I cook. Maybe he gets 18 of his cheesecakes. He's not getting 18 of my cheesecakes. Okay, we don't have fraud. Because me, the buyer, did not rely on your fraudulent misrepresentation statement, okay? So there's no fraud. I mean, it didn't, whether I enter in the contract or not, it wasn't because of your fraud statement, okay? So I got to actually believe it, okay? It's got to be the reason I contract with you is based upon the statement. And the final thing is that the buyer is harmed, okay? Or the listener is harmed. So say I buy your oven and it doesn't, for $1,000, and it doesn't cook 18 cheesecakes. And I put it on Facebook Marketplace for $2,000 and someone buys it. I wasn't harmed by your fraud. I made money on it. So I can't get anything back. Now say I put it on Facebook Marketplace. I can only get $600 for it. I have been harmed $400. I paid you $1,000. I got $600 back. I got $400 that I am out. And I would sue you for the $400 to recuperate. So to unpack all that, because you will probably see this on an exam, let me go through the elements again. Fraud is the misrepresentation or false statement, okay? That's just kind of what it is, with these 4 things. Knowledge that what I'm saying is false. The intent that the listener will rely on it. The listener actually does rely on it, and the listener is harmed by the entering into the contract. Okay, so you gotta know those 4 things. Very common, tested. And now let's talk about just in general, there's a lot of things that are just puffery, okay? So puffery is like salesmanship. So say I am at a restaurant, we use restaurant again, and somebody wants to buy a cheesecake, okay? They want to order a cheesecake. And they say to the waiter, how's the cheesecake? And the waiter says, it is wonderful. I love it. It's great. It's moist. And at the end of the day, it is my favorite dessert on the menu. Okay? And you buy it. And you're like, this is not good at all. It's not moist. It is the worst cheesecake I've ever ate in my life. Well, you can't call the waiter on fraud for giving his opinion, okay? And additionally, you can only expect so much truth when it comes to an opinionated question. Like, okay, so you say to a waiter, how do you like the cheesecake? What's he going to do? Tell you it sucks? No. That's not what's going to happen, okay? He's going to frame it, even if he doesn't love it, he's going to frame it as, oh, it's very tasty and a lot of people love it. It's just not my favorite. I prefer the double chocolate truffle cake. He may frame it in a manner like that. Or he may say, yeah, the cheesecake's good. I like it. It's not my favorite, but I do like it. It's good. And, he can say things. He's not going to tell you it's horrible, though. So you just have to understand that, okay? What would be fraud would be if he said to you, oh my, the cheesecake just won the Cheesecake Gold Medal at the Osceola County Fair. And they're like, wow, that's impressive. I want that cheesecake. Please bring the cheesecake to me. Now we got fraud. If that didn't happen, obviously, because the waiter knew that he knew the falsity of the statement. He knew it wasn't true. He said it because he wanted the listener, the patron, to get the cheesecake. The patron was like, oh, yeah, also kind of fair, gold medal winner. I'm in. He's harmed because he bought a cheesecake that he does not like and was a waste of his money. So, there you go. So he's out the $7, and that is what he can sue the restaurant for. Okay? So, kind of as we conclude our discussion on capacity, two types of capacity that we really want to discuss is duress, okay? Duress and undue influence, okay? So undue influence, I would make sure that you know this, okay? Undue influence, just kind of get the basic gist of what it is where there's one person who is an authority figure over another, and they convince them to do something, okay? Happens a lot in with older people and their children. Their children convince them to contract into something that they probably wouldn't have, but they got talked into it based upon undue influence because the children are like, I'll put you in the home if you don't. Or something like that. When we're looking at that, that's what undue influence is. Main thing I know is that there's one party who has, superiority over another party. Finally is duress. Okay, duress is a little different. Duress can be two types of duress. Okay, make sure you know these as well. Physical duress and economic duress. Okay. They're different. Physical is I'm going to punch you if you don't get into the contract. Okay? Economic duress is more of a financial duress. Like, for instance, if you don't enter in this contract, I'm going to no longer, provide such and such finances for you. Okay? Things of that nature are economic duress, and physical duress would be, obviously, I'm going to punch you. So that kind of is the end of our capacity lecture, and thank you for listening, and we will see you next time.